Chapter 10 of Tractate Yevamos continues discussing the laws of marriage. The first Mishnah says a woman whose husband went overseas and she was told that he died, so she remarried, and then the husband, as it turns out, had not actually died and returns. She needs to divorce both husbands and has no claim to the marriage contract, to the rights of produce, sustenance, or old garments from either husband. If she did take such payments, she needs to return them. Any child born from either husband is a mamzer, an illegitimate child, and if they are kohanim, they are not permitted to become ritually impure from contact with her corpse. Neither husband is entitled to her earnings, nor are they authorized to annul her vows. If she's not a Kohen or a Levi, she can no longer marry a Kohen. If she's a Levi, she can't eat Meiser. If she's a Kohen, she cannot eat Truma. Neither husband's heirs inherit her marriage contract, and if either die childless, their brothers do chalitza, not yibum. Some have particular disagreement. Reb Yossi says her marriage contract is valid with her first husband. Reb Eliezer says the first husband is entitled to her earnings and can annul her vows. Rabbi Shimon says the first husband can do yibum or chalitza and exempt her co-wife from doing either. And also their child is not a mamzer, so the child is legitimate. Now, all of this was if a single witness reported the husband's death, which is a special exception to allow women to remarry easier. If there were two witnesses that testified to the husband's death and she remarries, she's allowed to continue to be with her first husband if he reappears. If she had remarried from one witness, she needs to divorce both, and she's exempt from bringing a chatas offering due to the power of the court. If she had remarried from two witnesses, she needs to divorce her new husband and is liable to a chatas offering. If she was told that her husband died based on one witness, and then she just went and immorally cohabited with another man, and then found out that her husband was actually alive, she's liable to bring a chatas offering as she was only allowed to remarry. The Gemara says, although the wording in the first case says they testified, it refers to a single person's testimony based on the later part of the Mishnah, referring specifically to two witnesses in comparison to this part. Normally, we basically always require two witnesses for everything according to Jewish law. One of the only exceptions is in a case like this, where a woman's husband vanishes. It leaves her in stasis, essentially, without her husband, but unable to remarry, as she's not certain if he's dead or not. So in such a situation, there's a leniency to believe a single witness who testifies that her husband died to allow her to therefore remarry. This is also learned from other sources too. Another thing a single witness is said to be believed by if a single witness tells a person that that individual inadvertently ate chalev, forbidden fats. If that man doesn't dispute it, then he's liable to bring a chatas offering, and we bring sources which are disputed. There's further argument on these sources, and in the end it concedes that a single witness is actually not believed by an established prohibition. However, by the woman remarrying, that's permissible as it's a rabbinic institution. If she remarried from the testimony of one witness and the husband comes back, we said she needs to divorce both of them. Some say if there were two witnesses, she doesn't need to divorce her husband, but that's only where she cannot recognize the old husband and the witnesses also testify that it's the same man. It's still debated as to how she's allowed to remain married to the second husband. Some say it's where there were two arguing sets of witnesses who came as to whether her husband died, and then after she remarried, wherein this ruling was stated to disagree with an opinion that says she would need to leave her husband. Or some say it's where she remarried and then the second witnesses came, that she can stay married, and if she married after both witnesses came, she can't remarry, which actually means she's agreeing with the second opinion. This is for the disputed. Some say that actually it just means she can just stay with her first original husband. Regarding the case of a single witness, some say she only needs to leave the second husband if she recognizes that the returning husband was her original husband. If she says that's not actually him, she wouldn't need to divorce her new husband. The case is clarified to be dealing with two witnesses who say it was the original husband, but they would be normally disqualified, which is further discussed. She needs to divorce also the second husband, even though, as it turns out, her first husband was still alive. So it was effectively just adultery. However, it's a rabbinic institution, so that way people watching who don't know the situation won't think that she just left her husband without a valid marriage contract, and this is for the discuss. There's qualification by some related cases. Anyways, we said in the case that she doesn't get her marriage contract. This is because she did adultery effectively and must be divorced, and the whole purpose of a marriage contract is to discourage divorce. The other rights listed have the same status as the marriage contract, and the remaining points are also clarified. It also brings sources for many of these points, and there are additional proofs cited and discussed also for some additional points, like in regards to certain services in the temple. This is all discussed further along with points on the source for her Kohen children not being allowed to become impure for her corpse. We also said her husbands aren't entitled to her property or earnings, or to revoke her vows, which is something normally given to promote a happier relationship, but here we want them to divorce, so we don't allow such things. The remaining prohibitions are also explained. We also said there were 3 opinions who disagree with particular parts of the prohibitions. Some say that each later opinion agrees with the prior one, but the initial opinions disagree with the later ones due to their opinions on the severity of the prohibition. The last actually allowing cohabitation with Yibum, the second allowing monetary earnings, and the first allows only the marriage contract, which is collected even as the marriage ends. Others say it's the exact opposite. The initial opinions agree with the later ones, and the later opinions disagree with the initial ones. The marriage contract is taken from the husband and is the most strict. The second is more lenient, where it's the wife's earnings to the husband, and the third is cohabitation with Yibum, which would apply even after the husband's death. We also said that if she remarried on the basis of 2 witnesses, she can return to her original husband if he's found, and it's disputed if we hold like this. This opinion is argued on further from several different sources. It remains unresolved, and practically in a case, we go like the strict opinion. So if a woman remarries based on a testimony and her husband returns, no matter if it was with 1 or 2 witnesses, she has all of those listed penalties apply. If she remarries and there's just a rumor that the husband was still alive, she's not penalized. This means that the rumor is considered to be as if it came about after she married. Some disagree with the Mishnah's statement that she needed to divorce both husbands after the testimony of a single witness. There are sources brought. At the end, we discussed immoral cohabitation. Some say this refers to cohabitation outside of marriage. Some say this refers to a widow marrying a Kohen Gadol, or a divorcee marrying a Kohen, or similar. The first opinion would agree with the second, but not vice versa. Sources are brought. New Mishnah: if a woman's husband and child went overseas, and she was informed that first her husband died and then her son, so she married somebody else, and then after was told it was the inverse, that her son died first, thus requiring her to actually have done Yibum, she now needs to leave her new husband, and the child, either conceived before or after this occurred, is a mamzer. If they informed her that her husband had died first, so she did Yibum, and then she's informed that actually her husband had passed first, she needs to divorce, and the child, either conceived before or after this occurred, is a mamzer. If she was informed that her husband died, so she remarried, and was then told that your husband was actually alive when you had remarried, but died after, she must divorce, and the child conceived before this occurred is a mamzer, and if it's after, it's legitimate. If she was told that her husband died, so she betrothed somebody else, and then her husband came back, she can go back to him. If the second husband gave her a divorce document, she'd still be allowed to marry a Kohen. This is learned from the verse, and nor shall they take in marriage a woman divorced from her husband, meaning it had to be her actual husband. The Gemara clarifies points on the wording of the Mishnah. It says the child is born either first or last, which, as said here, refers to the child being conceived either before or after them being informed of the information, which is particularly relevant in the last case. Also, it says the first case, that the children of a woman who had actually required Yibum and accidentally she had married somebody else, her children are mamzerim, illegitimate. Some people actually disagree with this, as they hold that it's only a violation of a negative commandment involving marrying a relative that can produce a mamzer. There's a dispute between opinions if it's a valid act of betrothal when a woman who required Yibum accepts the betrothal from another different man. It's held that this is not a valid betrothal and she still requires a divorce document. Some say based on this, if such a thing occurs and her brother-in-law was a Kohen, if he does chalitza, she can then stay with the husband, as if she was divorced, she wouldn't be able to marry her Kohen brother-in-law anyways. Others say no, as then you're rewarding the husband for a wrongdoing. So actually it says that if her brother-in-law is a non-Kohen, her current husband can divorce her, allowing her to do Yibum with her brother-in-law. We said a woman in this situation's betrothal won't work, but there's a debate if Nisuin, the final stage of marriage, is effective. The final ruling is that betrothal is not valid for a woman who requires Yibum with somebody else. This is discussed along with a related debate if a person can legally do a business transfer on something that doesn't yet exist. It's further debated between several opinions based on several sources. It's further proven from related discussion that a single witness's testimony, if uncontested by any later testimony, is believed in order to allow a woman to marry through Yibum. This is further discussed with additional proofs brought. It also says from the quoted verse, and nor shall they take in marriage a woman divorced from her husband, that even more you can learn from this that a Kohen cannot marry a woman who is divorced from her husband under the stipulation that she couldn't marry anybody else later after she's widowed. She's still not allowed to marry a Kohen. New Mishnah: if someone's wife traveled abroad and he was informed that his wife had passed, so he married her sister, which is only now permitted, but then the wife came back, he can return to his wife, and he and the sister can still marry into each other's families. And if his first wife does actually die, he can go back and marry the sister. If this case occurred, but he had children, and he was informed that his wife was alive during the marriage but died after, the children conceived before his wife's death are a mamzer. If conceived after, they're legitimate. Others disagree with this principle, saying that anyone who disqualifies others is himself disqualified, and if he doesn't, then he isn't disqualified. The Gemara says in the first case, where his wife vanishes overseas and he marries her sister, if his brother-in-law, the husband of the woman he wants to marry, also vanished overseas, and they then return, the sister and her husband, the brother-in-law, can't be married, but he can still be with his wife. Other people dispute the whole principle from the Mishnah as to whose view it accords with, and it's discussed. He's also allowed to remain with his wife in this case, as he's only violated a rabbinic decree. The sources for this are brought and discussed, and there are related cases spoken on. It also clarifies the ending point of the opinion that says if someone disqualifies others, he disqualifies himself, which means he holds that if he disqualified his brother-in-law from his wife, he's also disqualified from his own wife. And when it said if he does not disqualify others, he's not disqualified, that refers to an earlier case where a woman remarried based on 2 witnesses, and her first husband returns. She's allowed to remarry her old husband, and the sister can remain married to the brother-in-law. There are other similar explanations given on this unique ruling. It also says in opinion that this is the ruling we hold like, but it's disputed. New Mishnah. In the event that a man was informed that his wife had passed, so he married her paternal sister, and then he was informed that she had died, so he married her maternal sister, and he was then told that she died, so he married her paternal sister, and he was then told that she died, so he married her maternal sister, and then he found out that they were all actually still alive. He's permitted to stay with the first, third, and fifth wives, and 2 of them would be exempt in the event of Yibum or Chalitza done with the third. He cannot stay married with wives 2 or 4, and if he dies, if Yibum is done with 1, the other is not exempt. If by this case the first wife actually had died, and then he married his second wife and so on, he can stay married with wives 2 and 4, and the other would be exempt from Yibum, and he can't stay with wives 3 and 5, and if Yibum is done with 1, the other is not exempt. A new topic, if there's a boy 9 years old and a day, if he does Yibum to marry his dead brother's wife, his older brothers can't do Yibum either, and vice versa. However, he can only disqualify his older brothers by doing Yibum, while they can disqualify him by doing Yibum, betrothing her, divorcing her, or by doing Chalitza. The Gemara clarifies the first cases, as was stated. It also discusses further points on the disqualification between such brothers by Yibum. New Mishnah. If a boy is 9 years and a day old, and he did Yibum, marrying the woman, if his older brother of the same age also marries her, the second brother has disqualified the first. Others disagree. If a boy of such an age does Yibum, and then also does Yibum to her co-wife, he's disqualified himself from both. Others disagree. The Gemara explains the logic of the disagreeing opinions, that only one of the Yibums could be legally valid, so one would always be permissible. With all of the above cases, it implies that the betrothals would be permissible, but others would disagree by the second case, with the co-wives saying that's not allowed. New Mishnah. If a boy of 9 years and a day does Yibum and then dies, his older brother does Chalitza and can't do Yibum. Generally, if a minor boy has married a woman and then died, he's exempt from Yibum and Chalitza. If a 9-year-old and a day boy does Yibum, becomes an adult, marries another woman and then dies, if the boy hadn't cohabited with the first wife after he became an adult, she does Chalitza with his brother and not Yibum, and the second wife can do Yibum or Chalitza. Others disagree, saying the brother can do Yibum with whichever he wants and Chalitza with the other. This all applies by either a boy of 9 years and a day or a 20-year-old boy that doesn't have the necessary signs of physical development. The Gemara discusses these points. It's qualified further, and it also mentions in regard to the non-physically developed 20-year-olds, other similar discussions refer to a saris, a man with an actual disorder, while ours does not. If such a thing occurs, meaning he's not a saris, but he's also never physically developed, he's considered a minor until majority of his years have passed, which is said to be 36 years. Also, it says as general advice, if such a thing occurs, meaning there's a boy who reaches an adult age without having physically developed, it was said to either gain or lose weight, depending on where it's necessary. And that's the end of chapter 10.